So very good. So last week we discussed the question as to whether there is an ethic independent of halacha, and my conclusion was that there was such an ethic independent of halacha. So now what I want to do is I want to discuss 15 ethical principles that I have identified. This is going through, I guess, in a secular setting, you'd say the sources, but going through the rabbinic literature, the Gemara, the poskim, and identified 15 different principles. These are all in my book. The sources you'll see is on the bottom, and there are 15 different principles. Chayav b'dinei shemayim. Go through and we'll try to reach as many of these as we can today. Bishapara, mechusar amuna, midat rishonim, and midarke shalom. And again, I'll explain each one and translate it obviously as we get to it. Midas chasidus and midas stom, midarke shalom, orla goyim and tikkun olam, ein lo olav ela tarumos, kedusha, holiness, imitatio dei, righteousness, kiddush Hashem, chil Hashem, lemigdar milsa, hakarat tov, equity, and lifnimishur sadin. So I'll try to get through as many of those as we can today. I will say to you that sometimes the dividing line between them is not great, but they're there, they exist, and I think we can effectively differentiate the different principles. So the first one is chayav b'dinei shemayim. Chayav b'dinei shemayim means that you are responsible by the law of heaven. So let me stop sharing this one and put up the second slide, which is here. Okay, so here are various cases where the Gemara, this comes from Talmud Bavli, Bava Kama 55b, 56a. The Gemara lists a whole range of situations where there is no legal liability because the defendant did not actively and directly cause harm, but there is liability according to the laws of heaven. So you can look at them. The harm here is only indirect. As a matter of law, the defendant would not be liable for the plaintiff's loss. Yet, because the perpetrator has indirectly caused the loss, he is ethically obligated to compensate the victim. For the lawyers and law students out there, you might say that there's an issue of proximate cause here. If that doesn't mean anything to you, that's fine too. We'll go through it. So just to go through some examples, A breaks down a fence belonging to B with the result that B's animal runs through the breach and is lost. Because A didn't actively do anything to take B's animal out of the place where the animal was fenced in, it's not considered a direct loss. And that's true of all these situations. So let's take some, and the bolds here, the bold in all these are just bolding that I've done to emphasize that they're not obviously in the original source. So for example, A can give evidence in court that will save B from financial loss, but A fails to testify. This is, by the way, this violates a commandment in the Torah that you should give testimony when you have it, when you're knowledgeable of the facts. But because there is no direct causation, A didn't do it. It's not like A testified falsely, but he just didn't testify at all. He doesn't have legal liability according to halacha, but there is an ethical violation. He violates this the principle, and therefore he has liability by the laws of heaven, which of course isn't enforced by a human court, by an ordinary court, but only in the court of heaven. We'll talk about what that means and what the consequences are of that, if any. So let's take the next one that's in bold. A does some work with B's red heifer, thereby disqualifying the heifer for ritual use and substantially reducing its value. This is the Parah Aduma, the famous Parah Aduma, the red heifer, which was very hard to find and very valuable, and it was necessary to be used in the purification ritual. If someone became ritually impure, in certain circumstances, they needed a red heifer the ashes of a red heifer to purify the person. And the red heifer had to have never been used for any work. Once, if it was used for any work, then the red heifer is disqualified from the purification ritual, and this very valuable animal becomes just an ordinary cow. So here, A goes ahead and does some work with the red heifer, thereby reducing its value because it can no longer be used as in the purification ritual. But there's no actual change in B. Nothing has happened. B is the same. It looks the same. It is all the same, except that the legal status has changed and it can't be used in the purification ritual. Here, the courts cannot enforce payment since no actual mark of damage is evident on the heifer, and it is only Torah law that renders the animal unfit. And there are a whole bunch of these that the loss is only indirect. Let's go to the bottom one. A's jar breaks in a public area and he fails to remove the pieces which later cause injury to B. The offense is one of omission and payment cannot be enforced by the court. Because there is no direct action, it's not that A did something to B, but A did something to a jar and then broke the jar and didn't remove the pieces. So in each of these cases, there is no liability. There's no legal liability in the human court because the defendant did not actively and directively cause the harm. So let me quote you what Louis Jacobs, the famous late Louis Jacobs, the great scholar, and here's what he wrote about this idea of chayev midinei shemayim, that someone is responsible by the laws of heaven. He says, a wrong has been committed, but there is a real obligation to compensate the victim. But this cannot be enforced by the courts because of certain legal technicalities. Since a man is obliged to satisfy the ethical demands his religion makes on him, he cannot obtain pardon until he has redressed the wrong he has done. The laws of heaven are also laws, and heaven insists that they be obeyed. So there is liability in the court of heaven, but that doesn't help and doesn't change anything in an earthly court. So what happens? In these cases, in any case presented by the court where there is liability by divine law, the court must inform a party so liable. So what does he do? The court says as follows: we will not apply sanctions against you, but you should fulfill your duty in the sight of heaven, because heaven will be your judge. So again, no legal consequences, but there is a divine consequence, as you would. Now, as I wrote in my book, this is on page 53. Thus, in these cases, the aggrieved party cannot enforce any right to compensation for any damages incurred. Yet the traditional sources advise that the one who caused the harm, albeit indirectly, is not blameless. That there is no remedy does not mean that there has been no wrong. And while the wrong is not compensable in an earthly court, the wrongdoer is culpable in the highest court, the one in heaven. He is therefore encouraged, if you will, to compensate the victim, though if he doesn't do so, he has no material detriment. So it's very interesting because one commentator points out, this is Boaz Cohen, the great and late librarian at the Jewish Theological Seminary, in his book Jewish and Roman Law, he talks about this, and he says that the measure of a society can be taken by how its citizens act in those situations where there is no enforceable sanction. And I quote, a society in which obedience to law is motivated merely by the fear of sanctions would scarcely rise above the jungle if it could exist at all. Obedience to the unenforceable, which is the basis of every moral system and every good society, may be best instilled by cultivating a reverence for God. So again, no liability in an earthly court, but liability in the laws of heaven. Now, so that's the category of chayev midinei shemayim. Let's go to the second one. The second one is mishapara. Mishapara means he who punished. So unlike the first ethical principle of chayev midinei shemayim, liable by the laws of heaven, this principle covers those situations where there is no obligation to perform, even according to the laws of heaven. So even heavenly laws don't require you to do this, but there is still an ethical obligation, if you will. So the paradigmatic example of this relates to one who reneges on a transaction based on his technical right to do so, since he has not performed a statutory act of acquisition. So let me put up on the screen an example of this, and you'll know what I'm talking about. Okay, so here's the example from the Gemara. This is from Baba Metzia, Mem Dalet Amud Aleph 44a. So here's what it is. If the buyer took produce from the seller, but did not give him money, so the buyer didn't yet give him money, neither buyer nor seller can renege on the transaction. The buyer, but that's a mistake. It should be either buyer or seller can renege on the transaction. If the buyer gave the seller money, but did not take produce from him, either one can renege on the transaction. So if they gave him money, but he didn't take produce yet, and they didn't make a kinyan. So a kinyan is a legal act of acquisition according to halacha, according to Jewish law. It can be picking up the object, it could be picking up a handkerchief and both of them holding on to it. But if there's no, or actually removing the product, the produce. But here, the money was given, but he didn't take the produce. He can renege on the transaction. But the sages said, regarding one who exercises his legal right to void the transaction, quote, the one who exacted retribution from the people of the generation of the flood and from the generation of the dispersion of the people who built the Tower of Babel will ultimately exact retribution from a person who does not keep his word. So, another Gemara says it's the one who exacted retribution from the people of Sodom and Gomorrah and from the Egyptians in the Red Sea. So the point is that this doesn't quite rise to the heavenly law. However, if you stand on your legal right, and you, in these circumstances, because of the technical fact that you did not yet make a kinyan, an act of acquisition, it falls under this favor of the heavenly law. And so what happens? Rabbi Yosef Karo, the author of the Shulchan Aruch, says, how does one accept Mishapara? What happens? So he's actually cursed in court. The Ramah, Moses Isserlis, from Krakow, the commentator on the Shulchan Aruch, writes that some say that the curse is said in public rather than in court. So actually, the person is cursed. It's saying that the one who exacted retribution for all these terrible things, he will ultimately exact retribution from you. So while you have the legal right to do so, standing on this legal right that you can void the transaction because there was no act of acquisition, gets you this curse, if you will. So that's another ethical principle that we see in our Torah literature. So that's the second one. Let's go to the third one. The third one is mechusar emunah. Mechusar emunah means he lacks faith. The person who does this lacks faith. Ein ruach chachamim nocha bo. The sages are not happy with him. So what's the situation here? So here, even in a situation where the parties reached a verbal agreement for the sale of goods, and no furtherance of the contract has been effected, so they reached an agreement, they reached an oral agreement, but this is a lesser standard, if you will, than the first one, than Mishapara, because unlike the Mishapara situation, the money was paid, but no statutory act of conveyance occurred. Here, there's no act at all. It's just a verbal agreement that something will happen. Let's say I agree with someone to sell him my car for $10,000. But we just have a verbal agreement. There's no writing. There's no act of acquisition. We just had a verbal agreement. And then I say, you know what? I changed my mind. I don't want to do it. And therefore, under Jewish law, under halacha, you would have no obligation But the rabbis declared that one who backs out of this contract is lacking trustworthiness. He's mechusar emuna, he's lacking faith, he's lacking trustworthiness, and thus he is ethically deficient. So this is a clear ethical judgment. The one who retracts offends the ethical standard that that a man's word, obviously a woman's word too, should be his bond, and therefore he's ethically deficient. So let me share the screen on the Gemara here, and we'll see this. Let's see here. Okay, so here you go. So here's the language. Here's the actual language of the Gemara. And this, excuse me, I said Gemara. This is actually the Rambam. This is Maimonides. This is Maimonides in his Mishnah Torah, his great code, and it's in the Law of Sales, chapter 7, part 8. So here's what he says. When a person agrees to a transaction with a verbal commitment alone, so this is what we're talking about, an oral contract, it is appropriate for him to keep his word, even though he did not take any money at all, did not make a mark on the article he desired to purchase, nor leave security. In other words, he's done nothing other than entered into a verbal contract or an oral contract. If either the seller or the purchaser retracts, although they are not liable to receive the adjuration of mishapara, so they don't go that far because they didn't do, there was no act at all. There was just a verbal agreement. It's not like money was paid. Certainly no kinyan, no act of conveyance was made, because then he'd have a legal obligation. So if he doesn't have that, they are considered to be faithless, and the spirit of the sages does not derive satisfaction from him. So this is the situation. If you enter into an oral contract, under halacha, you have no legal obligation. Now, of course, under secular law, you generally would, other than in certain circumstances like sale of property or contracts that can't be performed within a year, where oral contracts are not effective. Generally, in secular law, oral contracts are effective. So if I enter into an agreement with you, again, using the sale of the car, and we agree, there is an oral agreement and it's enforceable in a court. But under Torah law, that wouldn't be the case. But here's the ethical principle that if you don't carry forward with your contract, if you don't faithfully execute the contract, you don't have a legal obligation, but there's an ethical standard that you have breached. Now, there's another example that I cite in my book where the spirit of the sages are not pleased with a person, is a person who completely disinherits his children. So the Gemara, this is Talmud Bavli, Baba Basra 133b. The Gemara writes, the Talmud writes, if one writes his estate to others and leaves his children without any property, what he has done, he has done. In other words, his actions are legally effective, but the spirit of the sages are not pleased with him. So someone has the legal right to disinherit his children, but if he does so, the Gemara says that the spirit of the sages are not happy with him. So there's an interesting commentary on that, by the way. Reb Shimon ben Gamliel, the Tana, the sage Reb Shimon ben Gamliel adds, I think this is sort of interesting. If his children were not conducting themselves properly, then he says the sages are not displeased with him. But if the children are conducting themselves properly, then you're just creating dissension, and it's therefore the sages are not happy with you. I'd also add a second note. That's Avadia ben Avram of Bartanura, a classic commentary on the Mishnah, states that the law is contrary to Reb Shimon ben Gamliel, and that even if his children do not act properly, the sages are still displeased with him, since, and I quote, maybe his children will have properly acting children. So while his children, the disinheritor, the testator, might be correct in disinheriting his children, the fact is that maybe the children's children will act properly, and therefore he still shouldn't do it. So what does this mean? So the children have no legal right against the testator, against the father, let's say, who disinherits his children. And he owes no duty to his children. However, the concern exists that the testator has not conducted himself in a manner to avoid arousing feelings of animosity, to prevent alienation of filial affection, and to preserve harmony and tranquility. This is what David Bleich, a very famous modern halachist, writes in, quote, "Is there an ethic beyond halacha?" So Bleich claims that the disfavor of the rabbis here is due to the testators acting contrary to the Torah. Quote, "The sages have no enjoyment from the testator's action, but instead they are angry with him because the principal laws of inheritance, which he has disregarded by disinheriting his children, are contained in the Torah. So while there's no legal obligation, there's an ethical obligation to do as the Torah wishes." So what I would say is, while there's no legally cognizable duty, the testator has not taken the preferred course of action, and therefore the sages are displeased. He has deprived his children from their biblically preferred inheritance, and he has sown discord in the seeds of his family. He has acted in a way that is ethically irresponsible. Let me quote you from a very famous author, Menachem Alon, who talks about this idea. So here's what he writes. This is in a classic work. If you want to know anything about Jewish law, you can go to Menachem Alon, his former Chief Justice of the Israeli Supreme Court, and he wrote a classic multi-volume work called, it's on the screen, Jewish Law, History, Sources, and Principle. So this is a quote from page 150. "From the strictly legal point of view, a person may leave his property to whomever he wishes. However," and I'm skipping and just reading the bolded part, "however, the sages viewed the order of inheritance established in the Torah as they interpreted it, i.e., first the children of the decedent, then the other relatives in the order of their kinship, as the appropriate and preferred method of distributing an estate. Consequently, a bequest of property to those other than one's designated relatives, although legally effective, falls short from the moral standpoint and is displeasing to the sages. They are angry at him for having deprived his biblical heirs of their inheritance." And so again, this is an ethical principle. We don't find any legal obligation. The Torah says, lays out the preferred course of inheritance, but you don't violate any law. In other words, a court couldn't enforce any sanctions against you for disinheriting your children, but you clearly violate an ethical principle by doing so. So that's another one. Okay, let's go to the fourth one. The fourth one is called Midas Harishonim, the measure of conduct of the ancients. This is another interesting principle where this is a standard that goes beyond the letter of the law. It's an ethical principle, and it's found in the practices of what's called the former pietists, the Hasidim Harishonim, they refer to in Hebrew. So these individuals, the former pietists, demonstrated a higher level of piety and rigor that was typically required and or commonly practiced. In fact, many of these practices relate to ritual observances such as prayer. So they are not legally required, these standards, these acts of the level of conduct that was done by the former pietists. For example, there are references in Brachos, in the tractate Brachos, in the Talmud about the former pietists taking additional time for prayer. So this than the normal time or what the masses did. This was an elite level of conduct. So this standard exceeded the ordinary practices of the masses, for whom it sufficed to prepare for prayer of just a few minutes. Technically, the legal requirement is the time it took to walk 4 tvachim, which is a matter of seconds. The former pietists, however, would take an hour to prepare for prayer. So this was a higher level of conduct. So other such practices that of the former pietists mentioned in the Talmud are including tzitzis, fringes, in garments as soon as they were 3 handbreadths in size, and not waiting for the garment to be completed and worn. So the legal standard of wearing tzitzis, of a male wearing fringes on his garment, is only when a garment is complete. The former pietists went to a higher level, and as soon as the garment reached 3 handbreadths, they would put on tzitzis. However, these pietists also extended such practices to the ethical realm. So the Talmud, for example, records, and this is in Talmud Bavli Baba Kama 30a, the Talmud records that the former pietists would, the ancient pietists would hide their thorns and shards of glass in their fields and make a hole for these shards at least 3 handbreadths deep in order to prevent potentially causing harm to others. So this higher standard in ethical and ritual and social matters was not considered a required standard of behavior, but one to be emulated by those who sought the higher level of character of the pious. So this was just an ethical standard, again, that had no legal sanction, no legal force, but was considered praiseworthy by the sages. Let's go to the next one. The next one is Mipnei Darkei Shalom. I think this is a particularly interesting one. Mipnei Darkei Shalom, Darkei Noam. This is things that you do because of the ways of peace and the ways of pleasantness. So again, this is, I think it demonstrates a fascinating ethical standard. So certain standards of behavior are not based on legal requirements, but emanate from a values-based approach to life and to law. One example of this well-accepted standard of behavior because of acting because of peace and harmony is that, well, I'll get to some examples, but what this is, the concept is that the Torah asks man to conduct his affairs in a manner that is peaceful and harmonious, shalom, in a peaceful way, and that emulates ways of pleasantness. So let me give you some examples that are found in the Talmud. This comes from Talmud Bavli Gittin, the tractate in divorce of all places, where examples are provided that things we do because of ways of peace and harmony. And you might find some of these things interesting, and it may explain some things that you may not have thought about before. So the first one that we do because of ways of peace of harmony, not because it is a legal standard, at least according to that Gemara, is a Kohen, someone who is a descendant of the priestly caste, is called first to the reading of the Torah in the synagogue, followed by a Levi, a Levite, and then a Yisrael, an Israelite. There's no legal requirement that be done, but it's done because of ways of peace of harmony. An Eruv. So an Eruv is it's actually, well, I guess you might call it a legal fiction, although people get concerned when they hear the word legal fiction. But I'm not. Legal fiction is a very well accepted concept in Jewish law, and by the way, even in secular law. Let me give you an example of a legal fiction in secular law that you may not have thought of. Condominium, the idea of a condominium, that didn't exist until recently, until the 20th century. Before the 20th century, the only way to have a form of ownership in a building and of many apartments was a co-op, which is why, for example, many of the buildings in New York are co-ops. There was no condominium at the time. Some smart lawyer figured out a legal way to create ownership in a building called a condominium. It's essentially a legal fiction. Well, the halacha has them too. Selling your chametz, you might say, others disagree, is a legal fiction. It's actually a transaction. But even if it were, that has legal standing. So an eruv is a way of enclosing a public domain on Shabbos so that you can carry items. The halacha is that you can't carry either in a public domain or in a semi-public domain called a karmelis, but you can create an eruv to do so. So again, there's no legal requirement to create an eruv, but once an eruv is placed, you've always put it in the same location. This also could be talking about an eruv for a tchum, for going on Shabbos. If you're outside a city, halacha is you cannot walk more than 2,000 amos. An amma is a disagreement of what an amma is, but it's somewhere from 20 to 22 to 36 inches, depending on which opinion you follow. So you can only walk outside a city 2,000 amos on Shabbos. But if you place some food or something in advance of Shabbos in that location and make an eruv, you can go more than 2,000 amas, more than 2,000 cubits. An amma is a cubit. So you always place it in the same location so that people can take advantage of that. The cistern nearest the irrigation channel is filled first. An article found by a deaf mute by an insane person is protected under the laws of theft, even though an incompetent person is incapable of true ownership. A poor man who exercises his rights to take certain produce by cleaning the olives at the top of a tree has rights to those that fall below the tree. There are various categories of things that grow that are entitled, that belong to the poor. But if a poor person goes up and cleans the olives at the top of the tree, he hasn't yet exercised ownership. He hasn't taken possession of them. So if they fall down, technically, there's no acquisition. If you look at the bottom, I've highlighted it by Pentateuchal law. A poor man acquires legal title. This is a forgotten sheaf. So the olives is B. Takes hold of the fallen olives. So if someone takes hold of the fallen olives before A gets a chance to do so, B's legal claim to the olives is fully recognized. So if A goes up on top, cleans the olives, they fall to the ground, B takes them. B has a legal claim because he has actually obtained ownership by lifting them up. But this offends the notion of fairness, and therefore the sages awarded the olives to A and declared that it is theft if anyone else takes them, even though as a matter of law, it does belong to the person who picked them up by the ground. But because of the ways of peace, we don't want people fighting over who the olives belong to. The person who actually cleaned the olives gets them, even though by law he's not entitled to them. This is a quote from Aaron Levine, great scholar. Unfortunately, passed away at a relatively young age, but wrote a lot in this area. So this is a quote from him. So these are examples of things that there's no legal right, but because of ways of pleasantness, our sages said this is an ethical standard. So, this is based on the verse in the Torah that the Torah's ways of pleasantness and all her paths are peaceful. This comes from Proverbs 3:17. So the Torah's ways of pleasantness. So Abaya, the great scholar Abaya says in Tractate Gittin and Tractate about divorces 59b, he says a very interesting comment. He says all the laws of the entire Torah were decreed because they are the ways which foster peace and harmony. So it would appear, therefore, that this actually has biblical sanction because it comes from the Bible, it comes from the Tanakh, from Proverbs, from the writings, that the Torah's laws are all ways of pleasantness. So again, that is another ethical standard that we see, ways of pleasantness. The next one is also an interesting, I think they're all interesting, but some to me are just particularly more interesting. There's Midas Chasidus and Midas Stom. Midas Chasidus, it comes from the word Chassid. Chassid, by the way, doesn't necessarily mean someone who dresses like we believe a Chassid, we see a Chassid dress. Midas Chasidus means someone who observes more stringently beyond the letter of the law. And Midas Stom is the opposite. This is the measure of conduct of Sodom and Gomorrah. So the opposite of Midas Chasidus, the opposite of acting consistent and going above the letter of the law, is Midas Stom, is the level of conduct where someone who acts like Sodom and Gomorrah. So what does this mean in practice? So according to the laws of principle ethics, according to the principles of Jewish ethics, as we have seen, man should not stand on his rights without good reason to do so. So while one may have a legal right to assert a certain claim, if there is no beneficial reason to do so, if he doesn't gain anything. So here's the difference from the former principles. We said before, for example, in entering into a contract, you should go beyond the letter of the law, even if technically you're not required. But here, you have a legal right to assert a claim, but there's no you're not going to get any benefit from asserting the claim. We'll see an example of that. It's considered to be an unethical act to persist in pressing the claim. The classic example of such behavior is a squatter who occupies a landlord's vacant residential property that is not usually rented. So there's a property that the landlord has, he's not renting it out. Someone goes and squats and lives in that land. So when the landlord discovers the squatter, if the landlord seeks to collect the rent for the period of occupancy, this principle, under this ethical principle, the squatter would not have to pay, despite the fact that the squatter has certainly received the benefits from the occupancy, the value of which can be monetarily assessed. And in American law, we would say that he's at least liable under a theory of quantum merit. He gets the benefit of what he stayed there. Because the landlord has lost nothing as a result of the occupancy, he, as a matter of strict law, he would be entitled, but as an ethical act, he shouldn't do it. So here is the quote from Maimonides, from his code of law. This is in the laws of theft of lost property. If one takes up residence in the courtyard of another without the latter's knowledge, the courtyard is not intended to be rented. The occupant need not pay rent, even though the occupant in the past has rented a dwelling, because the tenant has benefited while the landlord has lost nothing, has not lost anything. This is the principle in law, that if one benefited but the other one didn't lose. And by the way, it's very clear that this does not apply if the squatter, if the tenant, whatever you want to call him, actually caused damage or caused the loss. If the tenant did any damage to the property, and even if he didn't, he would undoubtedly be liable for ordinary wear and tear in this circumstance. But he's not liable for rent. And he's not liable for rent under the ethical principle. So if the landlord insists on payment in such circumstances, although he has suffered no loss, he's legally entitled to collect the rent, but he would be exhibiting midat sdom, the characteristics of Sodom. This is an equitable principle of avoiding midat sdom. So in a situation, here's a situation where an individual asserts his legal right. He has a right to demand rent because the person lived there, despite the fact that he would suffer no loss from forbearance. Such an act is clearly prohibited, perceived negatively by the rabbis. Now, again, he would be liable to cause, he would be liable for damages and for wear and tear. Now, it's interesting because this sort of is the other side of the concept of midas chasidus, the virtue of going beyond the letter of the law, because you might say that the occupant should go beyond the letter of the law and pay the landlord. What is also interesting, and this actually comes up, I don't know if you carpool, this comes up. This is something that Aaron Levine points out, that it would be improper for the tenant to actually offer to pay the landlord, because then he would be encouraging the landlord to violate the midas chasidus. By the way, Aaron Levine was chairman of the economics department at YU for over 30 years. So he states, and this is a situation that comes up sometimes, if A offers a ride to B in A's car to a place where A is going. So A is going, you're going from Thornhill to Toronto, from Brooklyn to Queens, and you're going anyway, and you offer B a ride where you're going anyway. Aaron Levine says it would be midas sdom for A to accept B's offer to pay for the tolls. So B says there's a toll, not between Toronto and Thornhill, but let's say in Brooklyn and Queens, there's a toll. So since A is giving B a ride, B offers to pay the tolls. According to the late Professor Levine, it would be wrong for A to accept B's offer to pay for the tolls, and certainly A may not request B to pay the tolls, Why? Because it may induce A to accept the payment. So it can't be offered by B because it will induce him to accept the payment. His concept is as this falls under the principle of midas chasidus and midas stom. In other words, B is not causing A to incur any additional expense by B riding in A's car. So offering to pay for the tolls or paying for the tolls it falls under the same principle of a landlord and a squatter. There's no loss to A, and therefore he shouldn't be accepting the payment from the passenger, which I think is sort of an interesting manifestation of that. Okay, the next ethical principle is Mifnei Darkei Shalom Or Lagoyim and Tikkun Olam. This one gets into some really interesting areas. We've talked about Darkei Shalom for the ways of peace before. That was a previous ethical principle, but this one is slightly different. This is an ethical principle which talks about being because of ways of peace and being a light unto the nations. We know that that's an obligation of the Jewish people to be a light unto the nations. So this ethical principle covers behavior which falls under the rubric of being a light unto the nations, and Tikkun Olam, the repair of the world, which we'll talk about. You hear a lot about Tikkun Olam. What does it really mean? And I'll give you some, I think, are interesting opinions that perhaps you haven't heard before about this very well stated, but perhaps misunderstood idea of the ethical principle of Tikkun Olam. Of course, Tikkun Olam is not a legal obligation. It would be an ethical principle of repair of the world. So in addition, so what does this mean? In addition to the halachic, the legal obligations incumbent on all Jews, obligations also exist by virtue of a tradition of outreach to the nations of the world. This role is best exemplified by the prophetic notion that it is the role of the Jews to be Or Lagoyim, a light unto the nations. This, by the way, is based on a verse in Isaiah 49:6, where he says, "It is not enough that you should be my servant, that I raise up the tribes of Israel and restore the survivors of Israel. I will make you," this is God speaking, "I will make you a light unto the nations so that my salvation will expand to the ends of the earth." So from this verse in Isaiah, again, it's 49:6, the idea comes that the Jewish people have an ethical imperative, if you will, and it's not a legal obligation, but an ethical imperative to be a light unto the nation. So this imperative requires the Jewish people to convey to the nations of the world a superior moral message, to live justly, to live ethically, to live honestly, and to inspire them to live in peace with one another. So this message constitute the principle, l'saken olam b'malchus Shaddai, the duty of the Jewish people to repair the world, to correct the world by example, to be a light, a moral beacon to the world at large. By the way, that comes from the Olenu prayer. We say it all the time, l'saken olam b'malchus Shaddai, that to tikkun olam, to repair the world, to be a light unto the nations. So let me talk for a minute about this concept of tikkun olam. I write a lot about it in my book, and I spend a lot of time on it. I'm not going to go into that depth here, but let's just explore what that means. I believe that tikkun olam, as it is commonly understood, is not what is meant by l'saken olam b'malchus Shaddai, to repair the world under the kingdom of God. It does not correctly, the common notion of tikkun olam does not really express what that means. Tikkun olam is generally perceived to be an agenda of moral outreach to the broader world, generally associated with an agenda of social justice, social engineering, and policy. While those goals are certainly laudable and may well advance the course of humanity, I do not think they represent the proper meaning of tikkun olam and the classical sources, neither the divine nor the prophetic Jewish world. Let me share a quote with you, and you'll see what I'm talking about. This is from Byron Sherwin. To know my bias, Byron Sherwin, Alav Shalom, was my thesis advisor, and he's written a lot of books the great quality of their books is they speak to ordinary Jews in rational terms, in easy language. And he wrote a book about Kabbalah, which I think actually is probably the best introduction to it. But here's what he writes. One of the most popular Hebrew terms in America today, and he was writing this in 2006. He passed away, I think, in 2015, perhaps 15 or 16. At a young, he was 65, and left a tremendous body of work. So here's what he writes on Tikkun Olam. One of the most popular Hebrew terms in America today is Tikkun Olam, usually translated as repair of the world or mending the world. In many sectors of contemporary American Jewish life, Tikkun Olam has become synonymous with Judaism and with Jewish identity. Readily identified as the prime directive of Judaism and the centerpiece of Jewish ethics, Tikkun Olam usually denotes social action, social justice, and a politically liberal social agenda. The promiscuous, interesting new word, contemporary use of the term has identified it with an enormous range of social programs and artistic projects, and with advocacy for a plethora of political causes, secular and religious, some consonant with the teachings of Jewish social ethics, and some not. That is his idea of Tikkun Olam, and I agree with it. Again, I go into it in great length in my book why I believe that the way it is applied today as an agenda, and I'm not looking to get into the culture wars. I think whether you're left or you're right, the idea that Tikkun Olam is an agenda to outreach to the nations of the world beyond the idea of just being a light onto the nations, I think is not what is meant by the principle. And if you're interested in more about that, I'll just put in an ad for my book here. But I do think that it's overused and not quite what our sages intended. So let's turn to Mipnei Darkei Shalom, the ways of peace, which we talked about before. This is similar to Or Lagayim, a light onto the nations, but may apply more specifically to items which apply to non-Jews as well as Jews because of the ways of peace. Let me give you an example. Under strict Jewish law, if one finds an item that is lost, Hashavas Aveda, it's a mitzvah returning an item. Under strict Jewish law, that applies only to Jews. So if you find an item that a Jewish person lost, you are obligated as a matter of law to return it to that person. Under strict law, you are not required to return it to a non-Jew, but our sages very early on changed that and said, Mipnei Darkei Shalom, because of ways of peace, to avoid a Chilul Hashem, to avoid desecrating God's name, while you are technically under law not required to do so to a non-Jew, you in fact are obligated to do so. This might be an ethical principle, it might even rise to a legal standard, but it clearly is an ethical principle that falls under the rubric that because of the ways of peace and to be a light onto the nations. So that's the seventh ethical principle. The eighth one, and again, there are 15. We're not going to reach all 15. Maybe we'll get to some next week, although next week I want to talk about the concept of employment and economic activity in Jewish law, whether that has value, how did the sages see that? But if there's time, we'll get through others. But I do, again, talk about each of them in my book. So the next one is Ein lo olav elo taruma. This is another ethical principle which has no legal obligation. And this means that Ein lo olav, the one person doesn't have a claim to the other person, only he doesn't have a claim, a legal claim, but he has a complaint. So the Talmud mentions certain situations where a contractual obligation does not exist, but an ethical obligation arises out of an unfulfilled agreement between the parties. Thus, for example, and this is a little like other ethical principles, but there is a difference. An oral agreement for labor or personal services may, as a matter of law, be canceled prior to performance without any recoverable damages. So if I enter into an agreement that you will provide secretarial services for me, and you don't do anything in reliance on that agreement. You don't move across country to work for me. You don't do anything in reliance on it yet. Before you act in reliance on my verbal agreement for you to come and be my assistant, my personal services, whatever, I can cancel the transaction. I can say to you, I'm sorry, I'm not going to do it. Again, for the lawyers and law students among you, under American law, you might not be able to do that because of the concept of promissory estoppel. Again, something I won't get into. But under Jewish law, you are allowed to cancel the transaction as a matter of law. But if you do so, the aggrieved party has a justifiable moral complaint against the breaching party. So this applies specifically where the aggrieved party, let's say the person I've hired as a secretary, is able to mitigate his damages by seeking other employment. So there's no actual damages incurred. So because the aggrieved party can mitigate his damages, he suffers no monetary loss, and thus there is no legal recovery available. However, because the retraction caused inconvenience, because the person had to go out and find another job, but the person found another job, so there's no actual damages incurred, there's a violation of the ethical standard, and therefore the aggrieved party can complain. What does this mean in practical terms? The conduct doesn't meet the expected high moral standard. The Beis Din, the court that the aggrieved party goes to enforce the contract, will say you are not an ethical person, and this person has a right to complain, and there are potential consequences, communal consequences, where the person may not be called up to the Torah because of it. It's not harem, it's not putting someone under a ban, but it is a statement by the court that yes, there are no consequences for you canceling the contract for this person to be, in the example I'm using, my secretary, but you didn't act ethically. You should not have done that. So that's the standard. Okay, let's go to one more, which I think all will have time for, and that's, again, another very interesting and important principle. This is the principle of holiness, Kedusha, and imitatio Dei, imitating the virtues of God. So this is a guiding force for Jewish ethical behavior in everyday life and is designed to bring life to a higher state of existence. Man is, of course, when I say man, I'm talking about women too, I'm using in general, is instructed to conform his conduct throughout his lifetime, consistent with God's example. This comes from Leviticus, from Vayikra 19:2, where there is an ethical principle of you shall be holy because I, the Lord, am holy. So what's let me give you the quote here that makes this, that talks about this. So again, this is from Eliezer Berkovitz, a great writer. He had a tremendous influence on my thinking. He was a professor of philosophy at I think it was philosophy. I hope I'm right. If I'm wrong, let me know if you know. At the Hebrew Theological College in Skokie for many years, and he wrote some brilliant works that I find to be extremely relevant. But here's what he talks about in the Principle of Holiness. Holiness is being with God by doing God's will. Now, it is the will of God that man should act ethically. But if he acts ethically for the sake of the good, he is an ethical man. If he does so for the sake of God, in order to do God's will, he will be striving for holiness. And here's a quote, Berkowitz, Man and God 186. So this is a higher standard of conduct, and that is to be holy. Now, closely related to this is the principle of imitating God's ways. Solomon Schechter wrote, quote, in its broad features, holiness is but another word for imitatio Dei, imitating God, a duty intimately associated with Israel's close contact with God. So that's the principle of imitating God. So several biblical verses allude to the desirability of following God's ways, and that doing so involves more than just merely performing mitzvahs, the commandments. There are statements which express the principle of God in imitating God in many places in the Torah. So let me give you some examples of those, and I think with that we will end. Okay, so here are various statements from the Bible, from the Tanakh, that talk about imitating God and acting in His ways. It's a commandment. You shall observe the commandments of Hashem your God to go in all His ways. V'halachta b'drachav, from Deuteronomy. It's a method of coming closer to God. For if you'll observe this entire commandment that I command you to perform it, to love the Lord your God, to walk in all His ways and to cleave to Him. We see that this is a method of coming closer to God, is to walk in His ways. V'halachta b'drachav. A request that God makes of Israel. Now, Israel, what does God request of you? Only to fear the Lord your God, to go in all His ways and to love Him. So again, this is identified as an ethical principle. I put the note in from Rabbi Norman Lamb, the attribute of God, is to emulate God's mercy. Interestingly, Rabbi Lamb asserts that the concept of imitating God as applies to punishment only obtains in the case of the king or the government, whose role it is to punish criminal behavior. But for the ordinary human being, the ethical obligation that we see in these verses applies to imitating God's mercy, the attributes of mercy and goodness. So just to sum up, what we've seen, we've gone through 9 ethical principles that go beyond the letter of the law, that exceed the legal standard that is the minimum, but the ethical standard is to go beyond the letter of the law in certain circumstances. By the way, the 15th principle I spend, I think, the most time on, and maybe that's where we'll start next week, Lifnim Mishuras Hadin, to go beyond the letter of the law, which I touched upon last week. There's a dispute whether that's actually a legally required principle or it's an ethical principle. But whatever it is, it has some very specific attributes, very specific characteristics, which we'll talk about. Okay, let's stop there and let me go to the chat and see if there are any questions. I see one. What does the principle of Jewish ethics say about the ethics of a Jewish lawyer who helps their Jewish client? This is a very interesting question. I'll tell you about it. By parsing existing secular American law so that the client is able to avoid the legal consequences of their actions and actions. Okay, so there's an article that addresses that very point, and I will refer you to that article. It's by Stephen Resnikoff. Let me find it in my bibliography. Yes, so Stephen Resnikoff wrote 2 articles exactly addressing that question. Let me give you what they are, and then I'll try to answer it. He wrote an article called "A Jewish Look at Lawyering Ethics," a great article for all lawyers to read, by the way. It's 15 Turo Law Review 73, fall 1998. 15 Turo Law Review 73, fall 1998. The second article, which I think is also very interesting and literally goes directly to this question that I guess Janine asked, is "Lying and Lawyering, a contrasting American and Jewish law." Lying and lawyering. By the way, as a lawyer for many years, the clients often have the wrong idea. Lawyers are not allowed to lie for their client. They advocate for their client. They're not permitted to lie. That would get you disbarred. So the article is "Lying and Lawyering, Contrasting American and Jewish Law." It's 77 Notre Dame Law Review 937, 2002. 77 Notre Dame Law Review 937, 2002. By the way, if you miss any of these sites, you can buy my book, or you can send me an email, and I'll be happy to send it to you. But those are two articles that address that point. So the answer to your question, according to Reznikov, and which I agree with, is that a Jewish lawyer has a higher ethical obligation than a non-Jewish lawyer because he's bound by the Torah's laws and I think the Torah standards of ethics. And therefore, as you can read in those articles, he gets very specific about that. There are certain positions that one, as a lawyer, may legally take as part of advocacy, but cannot under principles of ethics. Let me see if I can think of an example that he gives. Yeah, things like bluffing, which are done in negotiations all the time. It's really an interesting question as to whether one is permitted to do that under halachic ethical standards. So I don't think there's a definitive answer to that. It's something that Reznikov goes into, and you might find it interesting. But there are likely things that are prohibited under ethical standards. Let me say that one may not do. Now, that might put a Jewish lawyer at a disability and may cause clients not to want to hire them. So those are really interesting questions. But I really do refer you to those articles by Professor Reznikov. I think it's a professor at Loyola in Chicago, Loyola Law School in Chicago. Any other questions? I'll turn it to the audio if anyone has any questions. Okay, I don't hear any, so thank you very much. Look forward to seeing you all again next week, as they say, same time, same station, where we will conclude. I'll go through Lifnim Ashuras Hadin and talk about the concept of economic activity in Jewish law. Be well and have a good day. Thank you.